Well, greetings. Welcome everyone. Must admit, when you have something starting at midday, I'm never quite sure whether I should be saying good morning or good afternoon. But welcome to this Lorega webinar. I'm Angus Tucker. My name is Angus Tucker. I'm the Managing Director of Lorega Solutions, the chartered loss adjusting side of Lorega. And our main speaker today is Dan Brooks, who's a senior partner at Wynterhill LLP. Wynterhill are our partner law firm, and through Wynterhill, we provide the Lorega expert, legal expert service. Obviously looking at arbitration today, the quote on the screen, that comes from an insurance clause, an arbitration clause from a policy in 1555, which I have to say, I had no idea insurance policies went back that far, many centuries before Lloyd's Coffee House. Seeing one going back that far, bearing in mind what we've been going through the last few years, it does make me wonder if they're bearing in mind the infectious disease clause and the COVID issues, whether there's a plague clause in that one, and if so, whether they've still got some claims outstanding as we have with the COVID ones. Dan and I have worked together over recent years on numerous disputed claims and with an excellent success rate. A number of these were on the basis of arbitration, and the very threat of arbitration can often result in a significant outcome. The question really is how you use arbitration successfully, because there's two approaches. One, it can be a negotiation tool, or if that doesn't work, worst case scenario, go through the actual arbitration process. But often, as we've found, the mere threat of arbitration is enough to bring an insurer to the negotiation table, break the logjam, and get the claim settled. So looking at an overview of what we're going to do today, what Dan will be covering, the areas that, why does it all matter? Why does it matter about arbitration, and what is arbitration? We're looking at the historical perspective, principles and the underlying theory of it, the different types of arbitration process. Again, I had not realized until working with Dan on this how many different types there are. A comparison to CPR litigation and the Ombudsman service. Different types of arbitration clauses you get in policies, and they can differ quite a bit. The strategy one needs, look at it, thinks about from day one, conclusion and general thoughts, and then leading to questions. So if I can now pass over to Dan to pick this up, and Dan, why does it all matter?
Thanks, Angus. Thanks to Lorega for inviting me to speak about my two favourite geeky insurance subjects, really. A, the history of insurance law generally, and B, arbitration. And in that context, why does this all matter? And Angus, I was just thinking that if COVID and COVID BI claims has taught us anything over the last 2 years, it's two things: that we need to know how to define a dispute when these major events happen, and we need to know how to design the processes, including arbitration, for resolving them. And I've sort of outlined all of the different myriad of things that insurance brokers, adjusters, coverage lawyers have to think about on day one when an insurance disagreement, let's call it that, happens. And it's tricky. We have all of these overlaying competing processes. We have a pre-action protocol, we have a court process with CPR rules, we have mediation, we have expert determination, we have the ombudsman, we have negotiations, and then we have arbitration, and within that, different forms of arbitration. And understanding what arbitration is and isn't is essential to giving the policyholder advice on day one when these business critical events happen. What I'm going to try and do is define arbitration and bring this to life and talk through the sort of practical things that people need to be thinking about on day one. And I mean, I always say, Angus, we talked about this yesterday, when whenever someone sends me some papers and says, could you have a look at this? Could you have a think about it? Could you give us some advice about, you know, who's right and who's wrong and how do we go about resolving it? The very first thing that I do is not look at the arguments, but look at the dispute resolution clause to see what it says and to see whether there is an arbitration clause. And if there's not one, you know, how we go about creating one and what that needs to say. And I always think about the end game. Where do we want to get to? What does the process look like? What evidence do I need? How am I going to get the policyholder to their required destination? And how am I going to put them in a better position than they were before they came to me, essentially? And there's quite a few things that feed into that that we're going to talk through today. So hopefully you're going to be asking me a few questions as we go along. And I'm going to try and weave in a little bit of insurance history along the way. And that quote, it's a fantastic quote, Angus, that you put on the slides that I stumbled across, actually. You know, the insurance geek in me was reading up on some insurance law, and I stumbled across sort of an academic's book about 16th century insurance law. I mean, and I didn't know, like you, I didn't realize there was 16th century insurance law. And when I started scratching the surface, what you realize actually is that back then, 16th century, they were actually resolving insurance disputes by arbitration. And if we just go back a little bit, sorry, I'm jumping around on the slide, but one of the fascinating things about the words of the arbitration clause, if anyone's paused to look at it, is that the parties to this 16th century insurance contract set out deliberately an intention not to use a court process. You know, it goes so far as to say that they want to use good, honest merchants to resolve their dispute and not to go to the law. I mean, I was sort of, you know, you get left scratching your head asking questions, you know, well, what was wrong with the law then? How did they resolve it? What was the process? Who did they use? Etc. etc.
So Dan, would you think that was driven by possibly a sort of general undercurrent or thought that at law, bearing in mind it was probably fairly new as insurance cover then, that judges really didn't understand it and so probably weren't the right people to try and resolve the dispute?
I mean, look, no one knows. We sort of have to sort of guess a little bit, don't we, and infer things. But the sort of academics, I mean, two quick facts. You know, an insurance dispute, there's documentary evidence for this, that there's evidence of an insurance dispute taking between 5 and 7 years to resolve, Angus, back then. So there's a good reason for using arbitration now, like now, back then, is that they wanted a quick outcome as quickly as possible, fairly, by an independent, neutral third party. And arbitration, of course, is much wider than just insurance. They've been using it for centuries before, you know, started writing insurance policies. But it's just an interesting fact. And the other one, just to flag very quickly, I will leave this on the slide, but one of the customs from the 16th century was that before an insurer could plead their claim defense before a court, an insurer had to first have paid out under the policy, and they were then expected to sue the policyholder to recover their monies under the policy, if indeed they wanted to dispute coverage. You know, if you mind-boggling concept, you know, if you try and extrapolate that to the modern day. Look, let me move on. We've got a lot to cover, and I want to get through the nuts and bolts of it, and then get into questions, both from you, Angus, and hopefully a few from our audience. But what is arbitration? I think there's quite a lot of misconception about what it is and what it isn't. And I just want to break it down and give people a better understanding of it, and then the sort of elements that people need to be thinking about if they're trying to design a process because they have a problem on their desk. There are sort of some general principles that make an arbitration, and these are contained within Section 1 of the Arbitration Act, as I put on the screen. I am going to sort of parrot a couple of these things and then sort of develop them, but they're important to understand. And it'll make sense when I get to all of the different arbitration processes. But look, firstly, an object of an arbitration is to obtain a fair resolution of disputes by an impartial tribunal. okay, without unnecessary expense or delay. That's what the Act says, 21st Century Act. And the parties should be free to agree how their disputes are resolved. This is really important. I'm going to develop this in a moment to understand exactly how free they are and why that represents the sort of liberal principles that underpin our whole entire system of contracting. And then finally, it's been determined that the courts should not interfere in a process in which the parties have agreed to arbitrate any dispute, including an insurance dispute. The parties have complete autonomy to contract on any terms that they want to resolve an insurance dispute before the dispute happens, i.e. an arbitration clause. And if you just pause to think about that, well, okay, you have freedom to contract, so what does that really mean? Well, all the things that someone needs to think about on day one, including things like all of the different directions of travel, including should we be mediating, should we send this to the ombudsman, what's the appropriate strategy, etc., etc. If people do have an arbitration clause or want to arbitrate, they need to be thinking about the following things. Where will that dispute be conducted? For us in the UK, obviously, the seat will normally be London, but it could be Edinburgh, it could be Belfast, and it could be Dublin. If you've got international insurance, the arbitration could happen in other centres like Dubai, for example. What law is to be applied? I mean, we take it for a given that it's English law, but if the parties wanted to, Angus, we could use any law to determine our dispute arising from events happening in this jurisdiction. We could apply American law, we could apply Irish law, or whatever, or we could choose to apply fair and reasonable principles like the ombudsman chooses to, whatever that means. Who will the arbitrator be? This is a good one where I think there's a lot of misconception. People think that it's going to be a judge or has to be a lawyer, and the truth is it doesn't. Often it's actually better to have a non-lawyer. It could be a surveyor, could be an engineer, could be an architect, could be a layperson, for Christ's sake. And often in the insurance context, you might have an underwriter, an expert underwriter, deciding insurance issues in an insurance dispute, whether that's sort of between a policyholder and insurer or an insurer and reinsurer, conceivably. What type of evidence will be permitted? Okay, how does this differ from CPR proceedings? In CPR proceedings, you're allowed to submit pleadings, witness statements, expert evidence, and you're allowed to give evidence before the court in person, using usually a barrister. But arbitration is very different. We don't have to have all of those things, and it's essentially a consensual process unless you've got a set of institutional rules, and I'll come on to those and what they include in a minute. You can vary the types of evidence that you have or don't have. So you could just have a paper-only determination, or you could have, or you could empower the arbitrator to decide what he or she wants from the parties in order to make the right decision. Disclosure. This is a big variable and a big contrasting thing to CPR proceedings. CPR proceedings, as most people know, involve some sort of disclosure. CPR disclosure involves sort of a process whereby people put their cards on the table at a stage of the process, post proceedings, in which they lay their cards on the table and have to disclose things that both support their claim, but also things that undermine their position and support someone else's position. Arbitration is very different, Angus, depending on the rules that you've got, whether that's ad hoc arbitration, LCIA, ARIAS rules. I'm going to unpack some of those processes in a minute. You usually do not have a CPR type disclosure test. You normally only provide documents that support your claim. You normally, and this is represented in LCIA and ARIAS rules, normally don't have an obligation to provide something that undermines your position. And that could be important if you think about that. If you've got a fair representation dispute with an insurer where there are issues of inducement or alleged inducement by the underwriter, will the underwriter have to submit things, give things to the arbitrator and to the other side that actually undermine their position that they were induced as a result of a misrepresentation or a non-disclosure? These are all things that need to be thought about on day one when the papers land on your desk. Speed, how long will the process take? Will it be the same length of time as the ombudsman or the court process? Well, that depends. But all disputes are different, but many people don't appreciate that you can resolve a dispute if you wanted to. And I'll come on to the RS fast track rules in a bit. But it's quite possible to get a decision within 6 months, maybe quicker in some circumstances. If you have the right issues and you have the right process and you have the right goodwill between the parties, you can get very quick, cost-effective, binding decisions on the parties. And that's why when I say, achieving certainty is a good thing, why I think there's real scope to be more creative in the process. Who pays? Who pays for all of this? Court process, the loser usually pays. The loser would usually pay the winner 60 to 70% of the costs that they've incurred, including disbursements, for barristers, etc. And the rules for arbitration do vary slightly. The rules, you do normally get your costs back in an arbitration process, but you can vary them importantly. So you could have each party bears their own costs, or you could have that each party shares the costs on a joint and several basis, including the cost of the arbitrator. But there are important differences, for example, in terms of ATE premium, which I think a lot of people don't appreciate. That if you're bringing CPR proceedings, Angus, and you need an ATE policy to cover you for the risk of adverse costs if you're unsuccessful, you are unable, as a matter of law, CPR law, you're unable to claim those costs back from the other side in CPR proceedings. So if you have a claim for £500,000 and you are successful and you are awarded £500,000, but it costs you £50,000 to take an ATE premium out at the beginning, and you have to pay for it at the end if you're successful, you are down on CPR proceedings. You're, subject to sort of other costs, issues that need to be thought about. You're essentially down. You've only really, have recovered 450,000. Whereas in arbitration, a lot of people don't appreciate that you can take out an ATE policy, and if you are successful, you will be able to recover most of that, if not all of that, from your opponent on success. So that's something to think about. Moving on quickly, how private should it be? One of the biggest differences between court proceedings and arbitration is that the arbitration process is private and confidential, and that if you share the existence of it isn't, but the process and the documents that are produced from it and the award are. And if you share that information with anyone other than the other party to the process or the arbitrator, you're likely to be met with a claim for breach of confidentiality, and that could be quite serious. Actually, could be serious for any, for all of us, and something we need to be very mindful of. And there are, when you're designing the process, you need to be thinking about who needs to see the documents, the award, etc. And you can, again, by consent, vary the sort of default principle that it's private and confidential. So that, I'm sort of spelling out these variables, Angus, but there's an enormous amount of flexibility in the process that I hope is coming across. And, I think, if you have the right arbitration clause from day one, or, you're creative, if you don't have an arbitration clause in your policy, and I'm going to come on to some of the sort of typical clauses that we see, there's nothing stopping you seeking to agree by consent particularly if you're a broker, and particularly if you've got goodwill with that carrier or that insurer, seeking to design and agree an arbitration process that's good for everyone. And hopefully by the end of this seminars, people will have a better sense of what that really involves. I'm not going to cover in depth all of the other sort of fundamental principles. They're on the slide for people to sort of
Dan, you're saying about discovery and documents and that sort of thing. Can or does the actual arbitrator, does he at all specify what needs to be provided? If he thinks certain things should be provided and they haven't been, can he specify additional things from either side?
Yeah, that's a good question. I mean, it depends on the rules, the set of sort of procedural rules that you have. There are sort of 3 typical sets of procedural rules that are sort of incorporated usually, Angus, either the Arbitration Act, you know, a default set of rules under 1996 Arbitration Act that's drafted very easily to read and is very digestible, and I've included it as a link in the resources section if anyone wants to take a look at it. Or you have LCIA proceedings and ARIAS proceedings that have their own sort of tried and tested procedural rules. And depending on what you've agreed, certainly under the ARIAS fast track rules and ARIAS rules, they are empowered to help decide what is and isn't needed from the parties as part of the sort of initial early procedural directions, Angus. But otherwise, no. If you've got a sort of just an ad hoc arbitration, the arbitrator is there to referee and ultimately decide the dispute based on what the parties have submitted. You know, the arguments that have been made, the pleadings that have been made, the documents, the witness evidence, the expert evidence. What he or she won't do is say, well, actually, I really think a site visit would be good, or I really think that you've got the wrong type of expert evidence, and I would like to see an expert report from an underwriter or someone else. It will really be down to the parties to decide that, unless the arbitrator has been empowered, and it's free for the parties to empower that person to decide what he or she needs as part of that process. And that's worth contrasting to, Angus, things like the ombudsman and the things like an expert by way of an expert determination clause, okay, that are different processes, that are not arbitration, that are not subject to the arbitration rules. And all of those sort of variables that I sort of outlined from start to finish are different when it comes to the ombudsman and a sort of dispute resolution clause that is what I would call that could look like an arbitration clause that is similar, because you're referring it to an independent third party, but actually on its true construction is not an arbitration clause. These are different things. Doesn't mean that, you know, what goes into the end game and what you need to be successful is any different. But certainly they are not arbitrations subject to the Arbitration Act or the default set of rules, etc., etc. And you have to be very, very careful in those circumstances. The ombudsman's different, and hopefully I'll have a few questions about that at the end. But the ombudsman is very different, and he or she, you know, may be a bit more inquisitorial about the process, Angus. Their jurisdiction comes from other statutory powers, and they're there to resolve disputes informally, apparently, with an ever-increasing jurisdiction in terms of the types of policyholders that they can that can be referred to them, and the value of the claims also now up to 415,000. I think last time I checked. But they're not subject to appeal. They're not subject to all of the checks and balances contained within the Arbitration Act. It's a very different process to it, and there are pros and cons to that, and sometimes it should be used. But again, at the outset, when you're looking at a problem on your desk for a policyholder who has a disagreement with an underwriter about how the policy responds on any given set of facts, you need to be thinking about all these things. and what really is going to put your client, what's good for your client in those circumstances. And an ombudsman process might be the way to go. Arbitration isn't always the way to go. I think my sort of message is that people need to understand what arbitration is and isn't, need to understand how flexible it can be, and they need to design, as I do on day one, the different options and give advice appropriately. Angus, unless you have any other questions, I'm sort of going to move on to the different types of processes again, just to sort of labour the point that we have what I call ad hoc arbitration under the Arbitration Act. We have arbitration clauses with LCIA proceedings, the London Court of International Arbitration. We have ARIAS, the Insurance and Reinsurance Arbitration Society. And sometimes we see, but this is the forgotten set of rules from my perspective, the ARIAS fast track rules. Now, I'm not going to go through the minutiae of all of those. They have slightly different processes for all of those variables that I touched on for starting the claim, pleadings, evidence, enforcement. There are some similarities, but also some important differences between the different processes. But one of the clauses that I want to flag to people, I have no idea whether people are familiar with this or whether they're not, but the ARIAS fast track rules that you can build into an arbitration clause require the parties to refer any dispute to a sole arbitrator, and the default position will be that he or she will look at the issues on paper, and it will only be decided on paper unless the arbitrator decides otherwise, and you'd have to make submissions to the arbitrator. But the sort of default position is that he or she has to decide, is mandated to decide the issues within 4 months, which is, if you think about it, is, the idea of resolving any coverage dispute within any insurer within 4 months is lightning quick. And I can say I have used this process before, and it's quite can be some hard work for those running it, but actually, to achieve certainty and to achieve a successful outcome, or maybe not, depending what happens, to achieve a successful outcome and certainty that in a way in which the decision isn't going to be appealed within 4 months is a fantastic sort of method for resolving disagreements and coverage disputes, in my personal opinion. Compare that to the ombudsman, where depending on what the issues are, and leaving aside what the ombudsman tells you now, you could be waiting between 12 and 18 months, maybe quicker if it's a lot easier, maybe longer if it's a lot more complicated. I don't know what other people's experiences of the ombudsman are. And that also compares to, let's think about a court process in which you also have to have a pre-action protocol process, which could take 6 to 9 months, plus a court process to trial that takes 12 to 18 months at least. That's a long process and an expensive one compared to some sort of quick-fire arbitration that could be done and dusted within 6 months, or in this case 4 months. And he or she does have the power, and you can vary this by consent, does have the power to consider costs, but the costs have to be strictly controlled and limited. So what that stops the parties doing is incurring disproportionate costs on relatively low value things and then seeking to claim them back from the other side. So all this, make me think that it's a tried and tested method for resolving something, and I think it's underused, is my own personal view. But
Dan, just think not just on the fast track one, but generally. So who actually chooses the arbitrator then? And who pays for them? How do you decide who the arbitrator is? Does it have to be joint agreement, or will somebody externally appoint one?
Yeah, really good question. Really good question. Again, you've got to go back to what type of arbitration you have agreed, either in your arbitration clause or by consent with the other side. If you've because either the Arbitration Act or the LCIA rules or the RAS rules will tell you the answers to those things. Angus. And normally what happens, excuse me, unless the parties have written into the contract, and would be quite unusual, but is possible for you to write in who that person should be at the outset. Essentially, you have to agree who it should be, or where the tribunal is more than one person, and sometimes it can be up to 3 people or more for more complicated things. But normally in the insurance context, between sort of 1 and 3, between 1 and 3 arbitrators involved. But normally you seek to agree who that person should be by consent, Angus. So it goes full circle. Does that person have to be a lawyer then, or is there a better type of person in the market, whether an underwriter or an expert, or it might be a technical issue, to determine certain factual issues? Who's the right person? Now, what normally happens is there's plenty of good arbitrators in the market, given the London market's reputation for resolving these things internationally. There's no shortage of good lawyers. But what happens if you can't agree who that should be? What your choice would then be in that sort of unlikely scenario is that you normally have a nominating body. So you'd normally go to the LCIA, the institution, or ARIAS, or you might have some other body named like the Bar Council, and you tell them what your dispute is, and they nominate someone, and it'll be written into the rules, and whoever they nominate is binding on the parties, essentially. I think there were some other questions there about costs, Angus. Was that right?
Oh yeah, just who actually? I mean, not each side's own costs, but the actual cost of the arbitrator. Does that depend upon who wins and who doesn't, or do you agree to share it 50-50? Or
no, it's a good question, because if you compare it to the court process, if you think about how you issue proceedings, you have to cough up £10,000 on day one to start CPR proceedings, and that can be a real barrier. That's the disbursement of issuing court proceedings alone, Angus, let alone your own costs, depending on how your lawyer might be paid, or what sort of funding arrangements you have in place. You then have disbursements and things like that. But one of the big differences between CPR proceedings and arbitration, of course, is that once you've paid that £10,000 as a process, you don't have to pay for the judge's time on an hourly rate basis. Whereas arbitration, as a concept, you have to pay for the services of an arbitrator, normally on an hourly rate, and you normally have to pay for the sort of the institution as well, using their rooms or whatever that might be. There's fees involved in that. And normally what happens is that the parties have to, normally the process is that I call it a pay-as-you-go basis. You have to pay the arbitrator sort of up front to start the process. They want a certain amount of money up front to start the process. And if you stop paying them, they will stop the arbitration, essentially. So that can be a barrier. But equally, again, depending on the process, what you don't have is a £10,000 issue fee. So if you just think about this in a practical context, and this is why it's been quite effective for you and I, Angus, in circumstances where we've been dealing with COVID claims and other PDBI claims, where you have a very strong view that an insurer has taken a sort of overzealous line on the value of the claim, or indeed the coverage issues. You've looked, and I agree with you, and we've developed the arguments, but the insurer is entrenched. And what we've done is essentially serve an arbitration notice that doesn't cost anything. It's frankly very easy to prepare. A sort of 2-page document that triggers the arbitration process under the Arbitration Act or the ARIAS rules, and kicks off the process, but you haven't really done anything. And it hasn't cost £10,000. It's a very sort of effective tool to it's a real warning shot to the other side, and it gets them engaged, has been our experience. And it can be a sort of, before you have to actually go on and do anything and incur any costs and do any work, it really is quite an effective, powerful tool, in my experience, for getting insurers to the negotiating table to say, really, do you really believe that the value of the claim is as little as that? Do you really believe, you know, that's the correct interpretation of the policy, you know, and it normally calls their bluff pretty quick, is my experience of that. Unless there's any other questions, I'll move quickly on to arbitration clauses, mindful of time. Example A on the slides is a sort of conventional, unequivocal, what I would call unequivocal arbitration clause with a LCIA rules. You'll see that it says, in the event of a dispute in relation to either A, the existence, validity, or termination of the policy, or 2, the quantification of any claim. In the event of any dispute about those 2 things, the parties will refer the matter to an arbitrator who will be appointed in accordance with LCIA arbitration rules. That's got the process for all of those sort of variables that we've touched on. And it makes very clear that the parties cannot issue legal proceedings and that it's an arbitration clause. Contrast that to, because arbitration clauses aren't always as clear as that, contrast that to the typical sort of arbitration clause you find in a PDBI policy, Angus, where it says, and I'll sort of read this from the slide just to labour the point, but it says that any difference as to the amounts to be paid under this policy, liability being otherwise admitted, such difference shall be referred to an arbitrator who will be jointly appointed in accordance with statutory provisions. And the statutory provisions they're referring to are the Arbitration Act and all of the default set of rules involved in that we've touched on. Essentially means the parties are free and need to agree what the process is by consent. Otherwise, they'll have to refer it to the arbitrator and hear of decide what the process should be. But some people misunderstand what the scope of this arbitration clause is and what it applies to. Some people perfectly understand that really this is intended for really quantum-only disputes. But for example, does it apply to an aggregation dispute, which is about money? For example, the number of claims that you have, or disaggregation, if you're trying to argue that. Does it apply to that, for example? And the answer, you know, is that this type of arbitration clause doesn't cover, you know, what I call pure liability issues, which will include an aggregation dispute actually, and is intended only for pure quantum only issues where this is the sort of key qualification, you know, all of the facts have been admitted. And there was a very recent case from this. I'm not going to go through the case, but I put a hyperlink to the case, a decision in the last couple of months, actually, DC Bars versus QIC Europe. And I'm sure QIC are probably causing many people on this call a bit of a headache with their position on COVID claims. But this was a COVID claim for a claimant, owner of a bar in the West End who had a COVID BI claim, who issued proceedings. And then bizarrely, insurers and the legal team acting for QIC tried to strike out the claim, relying upon this clause. And they were trying to say that this clause was wide enough to include all types of coverage dispute, not just a quantum dispute. And there was a preliminary issue, and essentially they got short shrift of that. And I did email the barrister acting for DC Bars afterwards, a chap called Neil Hex, KC, because it was just odd to me why anyone would try to run that argument, and his response was it was equally odd to him, and he thought that QIC came out looking quite bad from it and had to make all sorts of admissions that they wouldn't have otherwise had to admit before the judge in relation to that claim that is now carried on through court proceedings. So if there's ever any doubt about that, that's been put to bed recently. But where does that sort of all get us to, Angus? We're sort of 40 minutes in. I've been talking for far too long. I want to open it up to some questions for people. But where does all this get us to? You know, strategy. You know, I want to go back to day one. You know, that myriad of options that people, brokers, adjusters, and coverage lawyers have to think about on day one. You know, all of those different processes that you have to think about. And decide between, and create a strategy from. My advice is think about the end game. Always start with the end game in mind. Where do you want to get to? Either for the purposes of opening up a negotiation, or because actually this is going to go the distance, and you're going to need to get before either a judge or an arbitrator or an ombudsman and have it determined. What's going to feed into that? What evidence will you need? What will the process need to be? What will the cost outcome be? What do I want that to be? What do the rules need to be, etc., etc. Think about the arbitration clauses. I think there's a huge opportunity. I think I said at the beginning that if COVID has taught us anything, we need to be thinking about these things earlier in the process, and I'm sure people do. But there are real opportunities when building schemes with insurers to agree quick-fire sets of rules to resolve these things, really. And it doesn't have to have lawyers involved. It doesn't. The people running them don't need to be lawyers. One of the differences with CPR proceedings is that actually the policyholder can represent themselves in arbitration. Angus, we haven't actually spoken about that. A broker, if they wanted to and had this, knew enough about it, could with the policyholder, make representations to an arbitrator if that's how they wanted to decide it. These are things to be thinking about from my perspective. And look, I just want to finish on this, but and I'm labouring the sort of dispute resolution point, but when you've fallen out with an insurer, the dispute resolution and the parties are entrenched. The only thing you can do to compel them to pay the claim, unless you can send it to the ombudsman or send it to a court, a judge or court process, is to think about what your arbitration clause says. And if you have an arbitration clause in your PDBI policy, or indeed your financial lines policy, which actually isn't really fit for purpose and makes it very hard for the policyholder to get it up and running, for example, includes, I've seen arbitration clauses with a 3-man LCIA tribunal as the process defined in the professional indemnity policy. Is that really helpful to a policy? Who does that benefit? Does that benefit the underwriter? Because it makes it quite difficult and expensive to run that process over an 18-month period. Does that really help the policyholder? What use is it if actually the process can't be used quickly and cheaply, in my view? But there we are. I'd love to get back to the sort of insurance policy and questions on that and the customs of the 16th century insurance market. But we'll see what questions we get.
Dan, if there's no specific arbitration clause in the policy, if someone decided that they were really fed up with the insurer and they were going to sue them, and they went down the CPR, the full legal process, and ignored possible arbitration, but bearing in mind the growth of ADR in recent times, could you have the position where a judge would be prejudiced against it and hold against them and sort of say, look, you should have gone to arbitration first, you shouldn't be wasting the court's time? Could that ever happen?
Well, the answer is that you could actually have your claim struck out. If you issued court proceedings and you had a very clear arbitration clause in it, of the type in example A that is sort of unequivocal about the parties having to refer it to an arbitrator. If you issued proceedings anyway and ignored the arbitration clause, you're leaving yourself very exposed. And I would never advise this. But you'd be essentially leaving yourself exposed to a strikeout application. And there's plenty of authorities that enforce arbitration clauses, essentially.
But what if there's no arbitration clause in the policy? Would they still say you should redo that these days as sort of first course? Because it seems to be more and more are going to ADR.
Well, it's a good question as well. I mean, that's very different. If you don't have an arbitration clause, you can't be criticised by a judge for not arbitrating or not trying to be creative for the other side about that. But good good brokers and good coverage lawyers will create an audit trail before you start proceedings where you sort of demonstrate objectively that you've tried to avoid court proceedings. I mean, that's what you're really getting at. And you're right to say that the courts do expect the parties to have tried to resolve their differences before they issue court proceedings. And that may be by mediation, but the word ADR is obviously broader than mediation and might include arbitration, but also might include other forms of dispute resolution, whether that's an expert determination or something. They're all things for people to consider. If you've done nothing, okay, and you've just gone ahead and issued proceedings, either party, insurers issue proceedings as well, you know, then you may have, it will be a factor that comes into play when costs are decided either for you or against you, is the short answer, Angus. But the judge, you know, this is again a big difference to CPR proceedings compared to arbitration. The judge will have expected you to have thought about that, and in your sort of one of your first sort of CMCs, when you get together with the judge, he'll be saying, have you considered ADR? If not, why not? And you're going to have to tell the judge why not, you know. And there are sometimes reasons why it's not appropriate to have sort of thought about it at those stages. But you know, you are going to have to justify that to a judge at some point, okay? But you can't be compelled to arbitrate if you don't have an arbitration clause. You can only arbitrate if you don't have an arbitration clause by consent. So you need both parties to agree, and then you need to agree the process in an arbitration agreement and design that, okay?
Yeah. Just looking at the just what we've got here, interesting question from Stuart in the audience. He's saying that he notes that the arbitration clause applies to parties to the contract, but what's the impact on third parties under the third party rights against insurers? Yeah, it's a really good question, actually. And I have had this come up recently, where particularly if you're dealing with a liability policy, you know, and there's a third party claim, for example. That's the sort of classic scenario. An arbitration clause, I'm not aware of any authority that obliges a third party who has third party rights against insurers acts type rights, you know, to step into the shoes of an insured following an insolvency event. But you know, before the policyholder has, you know, that event has happened, before they're insolvent, does a third party have a right to join that arbitration process question? And I don't think they do, is the short answer. I think they would have to use a CPR process after the policyholder has obviously become insolvent, is the usual sort of trigger to things. But in a practical way, what normally happens, and the situation that I've been dealing with, you normally get around that because everyone wants certainty. A policyholder wants certainty. A third party who will be interested in it will want certainty. And an underwriter will want certainty. What I would suggest that you consider doing is negotiating with insurers to essentially qualify and vary the sort of confidentiality of the arbitration to allow transparency of the process and of the documents being exchanged as part of the arbitration, and the arbitration award that will be final and binding on the parties, to share that with the third party. Because often you might have a mediation process, and particularly under a liability policy, you will want to bring that third party to the mediation process that is running alongside the arbitration process. So it's thinking about all the practical things up front. But I mean, I haven't seen anyone successfully argue that as a third party that they should be and have a right to the arbitration process. And if you think about that, they wouldn't even know about it, because the arbitration is indeed private and confidential, and you're not allowed to be sharing that with a third party without breaching your obligations of privacy and confidentiality. Another question from Kenny says, is arbitration contingent on the insurers accepting liability? Yeah, good question. And let's just compare the two arbitration clauses, A and B, that we had, or the
are on the slides. Certainly in the first scenario, it's not, because of you've got to read, there's an point of interpretation about how broad your arbitration clause is. And in the first scenario, example A, it's very broad, covers everything, the existence and validity of the insurances, things like, fair presentation, but also the quantum of the claim. So insurers do not need to accept liability either in relation to coverage or the quantum of the claim in order to then trigger the arbitration process. It is a right. Once the dispute is crystallized, you can serve arbitration notice the next day. It's another benefit of arbitration, Angus, that you don't even have to have a pre-action protocol process that takes 6 months. You have a dispute, you have a coverage, your policy is avoided, the claim is declined. I can start arbitration the next day, theoretically. But contrast that to the second scenario that was contingent on insurers admitting coverage and facts giving rise to coverage under the policy. You can only arbitrate quantum of the claim in those circumstances where in open correspondence it has been agreed. So the practical point is I'd be writing to an insurer to say, you do agree the following facts, and you do agree that the policy responds in principle to the following facts, don't you? Please confirm that. Please confirm that. Once that is agreed, then you're creating the jurisdiction to create a quantum only dispute.
One more, probably final question. One more. If there's no arbitration clause in the policy, if one side requests or they want to go for arbitration, can the other side block that and go full legal or something if there's no actual clause in there? Does there always have to be agreement on both sides?
Yeah, if there is no arbitration clause in your policy, this is why it's so important. Day one, I've got a problem, it's business critical. What do we do? How do we get a better outcome for a policyholder? What are the things that I need to be thinking about? This is why on day one, I look at the dispute resolution clause before I look at the facts and work backwards. If there is no arbitration clause, that does not stop you creating an arbitration process by consent. So if you do not have an arbitration clause in your policy, and particularly where you're a broker, you're going to have goodwill, hopefully, with that carrier, and you should be able to go to them and say, look, come on, we agree to disagree. We know what we're disagreeing about. We know what the facts are. We know that we have different views about, scope of cover, causation, exclusions, whatever the point is. Let's agree to disagree, but let's deal with it sensibly. It's in everyone's interest to build a process that's fair and gets resolved quickly and is binding on everyone and is cost effective. And so you go through that sort of thought process that I sort of outlined, at the start, all those things that need to be thought about. And in those circumstances, you can agree an arbitration process, and in which, that can be run, and that will be final and binding on the parties, so long as you then translate that into a sort of agreement to arbitrate.
Okay, thanks. And if there's no arbitration clause, just out of interest, how would you advise someone if they're saying, well, you've got a dispute here, would you recommend arbitration or mediation?
Sorry, there is or isn't an arbitration clause?
No, if there isn't. If there is an arbitration clause, then contractually, presume you need to follow it. But if there isn't one, then would it be better to go arbitration or mediation?
Well, I don't think it's binary. I don't think you can say arbitration good, mediation bad, or vice versa, or court proceedings good, arbitration bad. This is the whole point. This is why you need to look at what the issues are. But in terms of mediation versus arbitration, or mediation versus court proceedings, or mediation versus the false, you need to be thinking about, look, at the end of the day, people want money in their back pocket, don't they? People don't want to instruct people like me. People want their claims paid or want money on the table as quickly as possible. And they need to be thinking about two things. My negotiation strategy, how do I get this to mediation? How do I get money on the table, and will mediation help? that, because mediation is a very different type of process. It's not a, it's a process designed to facilitate a settlement, or to facilitate through diplomacy, you know, a narrowing of the issues. It is not intended to be, and the mediator, unless the parties agree this, is not empowered to say one party is right and the other party is wrong. He or she is there to sort of close the gap and ultimately to settle the deal, really. And so if you think about that, you should be thinking about how you arbitrate or trigger an arbitration process or a court process alongside the mediation. Because if an insurer isn't prepared to mediate in the pre-action stage, which sometimes they're not, and that's their privilege, what you quite often find, in my experience, is that there's a much higher probability of them changing their minds once you've started an arbitration process, or indeed, in our experience, Angus, you know, very quickly after I've served an arbitration notice, you suddenly get a change of heart from someone that they are interested to mediate, even though that they've been saying for a long, long time no.
Yeah. Okay. Thanks, Dan. Well, we're virtually at 1 o'clock now, so thank you very much, Dan, for that very illuminating and very interesting presentation. I've certainly learnt a lot. If nothing else, I've learnt a lot about Elizabethan insurance law, and you know, there was insurance and policies around many, many hundreds of years before the Lloyd's Coffee House scenario, which I always thought was the start of it. So thank you, and thank you everyone for attending.
Thanks, Angus, and thanks to everyone.